Okay, so the next thing that I feel that we should get into that a lot of people definitely need some clarification on is the differences, benefits, pros and cons per se of doing it as an individual or attaining that item or doing it as a trust. Can you briefly go into that?
Sure. First, I'll go over as an individual.
Okay.
When you're an individual applying for an NFA weapon, you have to obtain your chief law enforcement officer's signature, commonly referred to as CLEO. The CLEO can be multiple different entities. The first one generally is the sheriff.
Okay.
But any judge who can hear a felony case is also considered a CLEO. The district attorney is considered a CLEO. Ostensibly, if you could get the Attorney General of the state to sign, that would be a CLEO.
Right.
So there are a couple different avenues.
Let me ask you this real quick. I was told that in Pennsylvania the state police are acceptable in that place. Is that true?
It is true, but they won't sign.
Really?
Everyone I've heard who has ever asked the Pennsylvania State Police to sign has been rebuffed.
Huh. Very interesting.
So I don't know what their position is. Something could change, but generally I believe what the Pennsylvania State Police will say is that they're not signing. They believe you should go to your sheriff.
Okay.
Other things that you need to submit if you are applying as an individual are fingerprint cards and also a photograph, a 2x2 passport size photo. One of the other issues that sometimes arises with an individual application is ATF is approving you, that specific individual, for ownership of that weapon. That means that you can't have or give possession to other people. Now, it's its own gray area, and I'm going to go into that a little bit. So the first issue that we commonly see is the married situation, where we have two spouses and the NFA weapon's kept in the gun safe.
Right.
Okay. If both spouses know what the combination is, but it's only registered to one spouse, technically that other spouse is in violation of the law.
Right.
It's constructive possession because they have the knowledge with which they could either open that safe and take physical possession in some way, shape, or form, whether it be knowing the combination or where the key's kept. The other situation that arises is wanting to give your children or spouse or that the ability to take the firearms out to the range without you being there. Clearly, as an individual, that cannot occur. You must always be in possession. Now, that being said, ATF is always concerned about a transfer occurring. And possession isn't exactly the issue we always have to concern ourselves about. It's the transfer.
Okay.
And what I mean by that is where you go out to the range and someone else wants to shoot your gun. If you're there in close proximity to them, you can allow them to shoot your gun. They have physical possession of it. However, ATF says that's okay. A transfer hasn't occurred because we look to custody and control. And although physical possession may rest with someone else, you're still in a position to have custody and control over that weapon.
Okay.
Now, in that same situation, although ATF will not define when a transfer occurs in that type of scenario, if you walked, in my opinion, 20 yards away and went in an outhouse, at that point a transfer likely occurred. Because you don't even know what that individual's doing with that firearm.
Right.
For all you know, they could be running up and down the range shooting at people.
Right.
Not something we want to think about, but,
but it's a possibility.
It drives the point home.
Right.
How can you have custody and control when you don't even know what's occurring?
Right.
So there is some proximity to the individual who's possessing the firearm that's required, but ATF won't tell us exactly.
They won't define it, of course, as they like to do.
Well, they want the gray area there so that they can prosecute whoever they want whenever they want and not be bound by their prior determinations.
Right.
So that's kind of the individual route. Now, with a trust, when you go and apply as a trust, you do not need to obtain a chief law enforcement officer signature because the trust is a fictitious legal entity. It doesn't have a criminal background. As such, there's nothing for a CLEO to sign off on. In a similar vein, because it is that fictitious legal entity, it doesn't have photographs or fingerprints.
Right.
So you don't need to submit photographs or fingerprints. Also, as another benefit to a trust, in how we design our trust, anyone who is a trustee can use and possess the firearms. So we can have multiple people able to possess. So in that family situation, we would list both spouses as trustees. Also, if they have any children who are 18 years of age or older, we can list them as trustees, or even any friends. It doesn't have to be someone related to the person starting the trust in order for that person to be listed as a trustee. Other benefits with the trust is that it is an estate planning device, so you don't list any of the assets held by the trust in your will or other estate planning devices. And the other benefit in the estate context is that a trust, unlike a will, skips probate. And what that means is when you die with a will, it gets filed with the court and becomes a public document where anyone is free to go and read it.
Okay.
With a trust, since it skips probate, it never gets filed with the court and remains a private document where the only people who know about it are the trustees and beneficiaries. So
that's a wonderful aspect of it.
Right. So I have some clients who go the trust route merely for the privacy aspects.
Mm-hmm. And another thing that a lot of people, I think out there should know is that a trust is a huge benefit if you have suppressed weapons or short-barrel shotguns or something like that for home defense. Absolutely. And let's say you're at work, your spouse is at work, either way, and one of you has to use that particular item, then there's no issues in court later on with possession or anything like that.
That's right. And there are people out there who will say, well, constructive possession, although it's been prosecuted in the past, it's never been prosecuted just where it was a spouse who had access to the combination or that. And while I'll acknowledge I haven't yet found a case, that doesn't mean that it's not illegal.
Right.
And that doesn't mean if you get on the bad side of ATF or local law enforcement that they won't prosecute you for it.
Right.
And that's the big issue that people have to realize. Just because there hasn't been, to my knowledge, a prior prosecution doesn't mean that there won't be one in the future. We only have to look to the Olofsson case where basically a worn-out AR-15 went full auto. Okay. And never prior, if it was aware, would ATF prosecute someone. There they prosecuted him.
Wow.
And convicted him.
Wow.
Because of the fact his AR-15, which was semi-automatic, would go full auto because of wear and if soft primers were used in the ammunition.
That's unbelievable.
And that's the type of situation we have to deal with, and I have to advise my clients on in advance so that they don't find themselves in that type of situation.
Right, right. And this is part of what we're dealing with, guys. We're kind of fighting an uphill battle, so to speak. We're trying to protect ourselves, and that's why I'm here with Josh today. We're trying to educate people and protect ourselves as a whole from nonsense like what he was just mentioning. Another one of the key places that I feel we need to talk is constructive possession. Now, for those of you out there that don't quite understand it, it's essentially a way for them to pin something on you, whether or not you intended on actually building an NFA item. Could you give a little more on that?
Yeah, there is generally an intent that's required to be shown, but they can show it through different means and sometimes through circumstantial evidence. And the issue that always comes up is where someone maybe has a short-barreled rifle, but they also have their regular Title I AR-15 right. as well. And the concern is, can I get knocked for constructive possession? Quite honestly, I wish I could give an answer to that.
Yeah, it's a huge gray area.
It is a huge gray area. That being said, I believe there are certain things that an individual can do to protect themselves against charging.
Okay.
So if you just simply have one SBR and one regular Title I gun, as long as they remain in that configuration, I think you're good. Also, the fact that you knew the law and had registered or transferred the SBR shows that you're cognizant of the right. fact that these are a special weapon type or platform that requires registration. So I think that bodes in your favor. If you have multiple uppers that are short-barreled versions and you have a Title I gun, that is where it becomes a lot more difficult.
Right. Like, to give you an example, let's say you had like an AR-15 pistol and an SBR, something like that, and you had different caliber uppers or something as simple as that. This is what he's referring to.
Right, and what I generally tell a client in that situation is, again, I can't guarantee that you won't be prosecuted for it, but to protect yourself, place all of those short-barreled uppers into a plastic container like you'd get at Walmart or that, mm-hmm. and label the box outside, only use with Colt M4 serial number, right. blah, blah, blah. And that is your SBR. Right. That shows, if it ever comes to light, that you knew that these could only be used, and you took a further step right. of ensuring that anyone who would see them knew that these were restricted only to use with that particular weapon system.
Right. So if they did choose to prosecute you, you've shown clearly that you understand that these are completely separate and should only be used with that item.
Correct. And I think that in that situation is your safest bet to try and prevent the possible prosecution for constructive possession. Obviously, another way around it is if you do have some other place to store them, keeping them separate and distinct, especially on different properties, is going to be beneficial to you. But I will say that does not mean that if you're waiting for an approval for a Form 1, that you place your short-barreled upper at your office and have your receiver, Title I receiver, at your home, that's okay.
Right.
Again,
because
we're
they
talking
can bang
about
you for that.
Right. We're talking about a situation where you already have an approved SBR and have multiple uppers and are trying to just simply make sure that you're in compliance with the law.
Okay.